Hi friends, we finished up to the share capital concept in our revision yesterday, and we will be continuing with the transfer and transmission until meeting we'll be doing in today's class. See, for your exam, whether if I read this material for company now, will it be sufficient is the question which has come for me in the last 2 or 3 days. Friends, I told you somewhere around 15 marks is going to be MCQ type. MCQ type question, if you study this material along with the sheets which I'm going to send you for the number limits, which I'm going to send you, that alone will be sufficient for MCQ. Nothing more is required for the MCQ purpose. And for the descriptive questions, you should know the concepts, then only you will be able to answer the descriptive questions. Of course, the keying in words will not exceed more than 30 to 40 words in your examination for this attempt. So, this material will be worthy for you for the purpose of the revision a lot. With this material, you will be able to capture as much as mark as possible. The only thing is that you need to study this material on a regular basis. Only if you do it on a regular basis, you will be able to understand, you will be able to do it. So please ensure that you study this material, this 25 pages material on a daily basis in order to get more marks in this examination. I start with the transfer and transfer of shares. Shares are movable property which is transferable in the manner specified in the Articles of Association. So please understand, shares are movable property. Articles of Association should specify the manner in which it can be transferred. The shares of the company are freely transferable. Private company cannot impose absolute prohibition on transferability of shares. It cannot impose absolute prohibition, but it can impose restriction. Public company can refuse to transfer the shares for sufficient cause. If there are sufficient reasons, then the public company can also refuse to transfer the shares. The notice of refusal to transfer the shares must be given by a private company within 30 days. An appeal against the refusal can be made to the NCLT in the specified time. NCLT stands for National Company Law, National Company Law. An appeal against the refusal to transfer the share of a private company can be made within 30 days of the receipt of the notice of the refusal. The appeal against the refusal of the transfer of shares of a public company can be filed within 30 days. Friends, the point number 5, please change it to in case of a public company, the time period is 60 days, friends, not 30 days. Appeal against the refusal to transfer the shares of a public company can be filed within 60 days. In point number 5, please change it instead of 30 days, it is 60 days. The application of rectification of the register of a private company is to be made within reasonable time to the NCLT. I'm going to the point number 8. Every member who is an individual can make a nomination. They can specify who is going to be the nominee on the death of the person who will get the shares can be specified by the nominee. Only an individual can be a nominee. A minor can be named as a nominee. Shidhan, please mute yourself, Shidhan. The minor can be named as a nominee. A nomination can be made or varied or cancelled at any time. If a will has been written, in favor of X by the shareholder, and Mr. Y has been specified as the nominee. Between X and Y will prevail over the X. Between X and Y, the Y will prevail over the X. The nomination should be given in the form SH13. In the form SH13. The chat, it's form SH13 for the nomination. Need for certification arises where a member intends to transfer only a part of the shares or shares of the one share certificate to two or more persons. So if joint shareholders are there, there is a concept called transmission. Transmission means on death or insolvency of a person to whom the shares will go, to whom the shares will be passed on. That is called as transmission. If there is a death of the joint shareholder, let's say A, B, C are together shareholders. If any one of them dies, then what will happen to shares? The shares will be passed on to who? B and C. Are you getting it? If A, B, C are shareholders, three shareholders, if A dies, the share will pass on to B and C. Only B and C will be the shareholders. I'm going to the 9B. A need for certification arises where a member intends to transfer only a part of the share or shares of one share certificate to two or more persons. Suppose when I am transferring the shares, the name of the transferee is not mentioned in the share certificate, and date of the signing is not mentioned in the share certificate, it shall be called as blank transfer. I repeat again, usually in the transfer, name of the transferor, name of the transferee, date of execution, all these will be specified. If the name of the transferee and date is not specified, it is called as blank transfer. This is done in order to avoid the stamp duty payable on the transfer. A minor cannot become a member because he does not have a contractual capacity to enter any valid contract. But a minor can become a transferee of a fully paid up shares through a guardian. The shares of one public company are freely transferable and not of a private company. The shares of one public company are freely transferable and not of a private company. I am getting into the next topic, namely membership. Every company must have minimum members. What is the minimum members? In case of one-person company, 1. In case of private company, 2. In case of the public company, 7. Okay. So what is the logic behind 127? There is no logic at all behind this number. In England, it is 127. In India, also 127. That's all. The Indian law has been borrowed from England. So in England, it is 127. In India, also, it is 127. The company having no share capital does not have any shareholder. The company having no share capital does not have any shareholder. There will be a member, but not shareholder will not be there. What is the difference between the terminology member and shareholder? Even though the terminology member and shareholder are interchangeable terminologies, there are certain cases a person is a member but not a shareholder. What is the difference? Shareholder means a person holds the share. Member means a person whose name is entered in the register of members. A person whose name is entered in the register of members is called as member. Okay. So usually shareholder and member are same, but there are cases there is a small difference. Suppose A is the just a minute, friends. Suppose A is the member of the company. He is also the shareholder of the company, holding 1,000 shares. On a unfortunate day, A dies. B and C. A dies, the son B becomes the member of the company. B becomes the shareholder of the company. Until the time B's name is entered in the register of the member, B will be a shareholder, but then in the register of member, whose name will be there? A's name will be there. I repeat again, A is holding 1,000 shares in X Limited. A dies. The shares will pass on to B. Once the shares pass on to B, B will apply to the company X Limited stating that my father has died. Even after I am the member, I am the shareholder. Please enter my name in the register of member, he will say. Company will take its own sweet time, maybe 25 days, 30 days, 40 days to enter the name of the son's name in the register of member. In this time, B is a shareholder but not a member. So you are understanding the difference between the shareholder and member. Member means a person's name should be entered in the register of member. In the given case, A name will be entered in the register of member, even though he has died, still will be called as a member. Because his name is there in the register of member. So whomsoever's name is there in the register of member, that person is called as a member. When a person subscribes to the shares of the company through a memorandum of association, once the memorandum of association is signed on the registration of the company, he becomes the member, even though no shares has been allotted to him. Further say that minor cannot become a member of the company since he is not competent to contract. Minor cannot become a member of the company since he is not competent to contract. Minor can become a transferee of fully paid up shares through his guardian. Minor can become a transferee of fully paid up shares through his guardian. A company registered cooperative society, any registered society, central government, state government, all can become a member of the company as all these are separate legal entities. Point number 2B is very critical for examination. They will ask you whether the minor can become a member of the company. Yes, he can become a member of the company through guardian. It's a mock examination question papers and question which has been given in the series 2 Minor can become a member through his guardian. Note down the word guardian, very important. Through guardian, he can become a member. On attaining the age of 18, he on his own can become the member. Until that time, the shares will be held only in the name of the guardian. A partnership firm, Hindu-funded family, and trust cannot become a member. But on behalf of the partnership firm, partner can be a member. On behalf of Hindu-funded family, Karta can be a member. On behalf of the trust, trustee can be a member. A partnership firm can become a member of the licensed company as per section 8. A company can become a member of the another company if it is so authorized by the memorandum of association, since it is a separate legal entity. But a subsidiary company cannot become a member of the holding company except in 2 cases as specified in 19. We already saw the 19th section. Please go back and see it. Except in 2 cases, it can become. Every shareholder need not be a member. Holder of share and legal representative of the deceased member are shareholders and not members. We saw this just now. I gave an illustration, A and B as the illustration. So please note on that. Every member need not be a shareholder. Following are the members but not shareholders. Members of a company limited by guarantee, no share capital. Unlimited company having no share capital. When share itself is not there, how can there be a shareholder? That's why they will be entered in the register of members as member, but they will not be shareholders. List to be contributaries who cease to be a member within 12 months before the commencement of the winding up. Deceased member until the removal of his name from the register of member. Deceased member until the removal of his name from the register of members. Subscriber to the memorandum of association before allotment of shares. Subscriber to the memorandum of association before allotment of shares. Various modes of acquiring memberships are shown below. Subscription to memorandum of association. Application and allotment of shares. Transfer of shares. By transmission, by acquiescence or estoppel. Acquiescence or estoppel means a person who has agreed or been silent of being a member, he receives the dividend or he receives the notice for the meeting, he enjoys all those things. Subsequently, he cannot say that I am not a member. Accidentally, his name is entered in the register of members. He should take action for the removal of his name from the membership. If he is not taking so, he is estoppling. Borrowing powers and debentures. A trading company need not have express power to borrow in its memorandum. It is a practice that memorandum of association will state so. A non-trading company must have a power to borrow in its memorandum. Non-trading company means section 8. A private company can exercise its borrowing immediately after obtaining the certificate of incorporation. Friends, please note down this now. A private company and as well as a public company. Both this company can obtain incorporation. After the certificate of incorporation, they need to file a declaration that subscribers to the memorandum have brought in the capital. Then only they can borrow money and can start the business. I repeat again, a private company as well as a public company can do the business, can do the borrowing only after filing a declaration with ROC. Then only they can start the business. The declaration should state that the subscribers have brought in the subscription money. The declaration should be given in the Form 20A. The declaration should be given in the Form 20A. May I put in the chat? Form 20A. What I will do also, friends, for examination purpose, you need to remember some 10 to 15 form numbers for company law purpose alone. If you remember 15 form numbers, some 2 marks or 4 marks may come in the examination. Whichever is the important form, that form also I will put a table and send it to you. So study those form numbers, that will be useful for your examination purpose. Okay, I will put the purpose and I will put the form number, because in examination sometimes they will ask you what for this form is filed. So you should know the purpose also. So purpose and form number, I will put, so many forms are there in the Companies Act. I will put you, just give you 10 to 15 form numbers. Remember that alone for the examination, that will do. Okay, because I have attended all the 6 mock papers. I know which are all the areas they are asking you. I know that those are the questions which are going to be asked. You could have also attended the mock examination, so you may also know that which are all the forms they are asking. So be concentrate on those forms. In spite of that, I am also going to send you a sheet which will carry the form numbers. Okay. Debenture provision. Debentures, a company can issue debentures convertible or non-convertible. A company issued debentures to more than 500% of subscription is required to appoint a debenture trustee. A company issuing debenture should execute debenture trust deed and not later than 60 days after the allotment of debentures. The secured debentures, no secured debentures can be issued beyond for a period of 10 years. However, a company engaged in setting up of infrastructure project can issue debentures which are redeemable not beyond 30 years. Whatever we saw, the provision for the preference shares is quite similar. For preference shares is 20 years and 30 years. Here is 10 years and 30 years. A company issuing NCD shall create DRR equivalent to 10% of the amount raised by debenture issue before the debenture redemption commences. No DRR is required for the debenture issued by all India financial institutions and banking companies. Please note down all India financial institutions and banking companies. These percentages are vital for your examination. So remember those numbers. If NBFC registered under RBI, a DRR for the debenture issue through public issue. If it's privately placed debentures, no DRR required. So when DRR required, when DRR not required, have a classification. Then put on the percentages. That will do for you. Not less than 15% should be deposited on or before 30th April every year. The debenture redemption reserve shall not be utilized for any purpose other than the redemption of debentures. A person who owes money to a company can be appointed as a debenture. A partnership firm cannot be appointed as a debenture trustee. A creation of debenture redemption reserve is mandatory in case of debentures. Minimum subscription is not required in case of debentures. Minimum subscription is not required in case of debentures. There are 4 statutory books which need to be maintained. Register of charge if a security is created, register of debenture holder, index of debenture holder, foreign register of debenture holders. The return of allotment is not required to be filed with the registrar in case of the allotment of debentures. If pari-passu clause is included in the debenture, then after the execution of deed containing the charges, or where there is no deed after the execution of any debenture of the series, the prescribed particulars must be filed with the registrar within 30 days as per section 77. There is a very critical concept, namely charge. Charge is nothing but creating a security for the loan. If a company borrows money, the company need to create a security on the borrowed money with the assets of the company. That is called as creating charge. Pledge of a movable property by the company is not called as charge. The particulars of every charge should be filed with the ROC within 30 days. If it is not filed within 30 days, it can be filed within next 30 days, that is within 60 days, by paying an additional fee. If it is not done within the next 60 days, it can be done within the further 60 days. If it is not done so, then the charge cannot be registered at all. If a charge is not registered, the creditor shall be treated as an unsecured creditor. Are you getting the numbers, friends? Can I put into the chat? I will put you in the chat. 30 plus 30 plus 60. Totally 120 days is there for time for registration and modification of charge. If you are registering within 30 days, normal fees need to be paid to the ROC. If you are registering within next 30 days, additional fees need to be paid to the ROC. If you are not registering within the first 60, the next 60 you can register along with the payment of ad valorem fees. Ad valorem fees is a fees paid on the assets charge loan you are creating, that into certain percentage, 0.050% you need to pay. That much you need to pay on the asset. Okay, are you getting it? Any doubts, friends?
Sir, can you repeat it again?
The chat what I have given, 30 days you need to register with normal. If it is not registered within 30 days, in the next 30 days you can register with additional fees. If you are not registering within the first 60 days, further I will allow you 60 days. If in 60 days you can register by the payment of ad valorem fees. Ad valorem fees is a percentage on the total value of the charge created. If you are not registering within 30 plus 30 plus 60, that is 120. After the 120th day, you cannot register or modify the charge at all. The person will be treated as the unsecured creditor. Charges requiring registration. Following kinds of charge are mandatory and these charges need to be registered. Securing issue of debentures. Uncalled share capital, immovable property. Someone is asking me what is 300 days. I repeat, for 300 days, satisfaction of charge, there is a concept. Satisfaction of charge means company has paid the money to the lender. That means he is satisfied. Then you will file a return with the ROC by stating that the amount has been paid. The ROC will note it down that the amount has been paid. The charge will be taken away from the company's name. That is called a satisfaction. The satisfaction can be filed within the 300 days. Okay. For satisfaction 300 days. For registration and modification, it is 120 days. Uncalled share capital, immovable property wherever situated or any interest therein, book debts, charge not being a pledge on any movable property, a floating charge, a charge on calls made but not paid, charge on ship or share of a ship, charge on goodwill, in all these things, patents, trademarks, that is intangible assets, and all these things, charge can be created. In case of the non-registration of charge, it shall be void against the liquidator and the creditor of the company. This is what I told you, there will be unsecured creditor. The charge shall not be void against the company. That means they can still collect the money, but they cannot recover the assets. I'm going to the 8th point. 7C and 7D are immaterial. Company must give intimation to the registrar of the payment of the charge within 30 days. If it is within 30 days, normal fees shall be paid. If it is not registered within 30 days, it can be registered within 300 days. For that, you need to pay additional fees. Okay, within 30 days, normal fees. Up further 270 days, that is 300 days, with additional fees. A company or a person interested in charge can register the charge. Fixed charge can be created by any person. Floating charge can be created only by an incorporated person. Floating charge is a charge made on the stock in trade. Floating charge is a charge made on the stock in trade. It's called as floating charge. The register of instrument of charge shall be open for inspection to any member or creditor of the company or any other person. I am going to the meetings and procedures talk concept. Every company shall keep and maintain a register of members and index thereof. The register of members shall be maintained in the form MGT1. Register of members shall be maintained in the form MGT1. A company is having less than 50 members, the index need not be maintained. Index means in alphabetical order, you need to maintain the name of the persons. That is called as index. If less than 50 members are there, then there is no requirement of maintaining form on index. You can have the register of members as and when the members become the member, you can, on a chronological basis, you can have it. There is no requirement of index. Every company shall prepare the annual return containing the following additional particulars as of the close of the financial year. It should be signed. It shall be filed in the form MGT7. Important from examination perspective. Constantly asked in your mock papers. MGT7 in form for annual return. Annual return of a listed company having a paid up share capital of rupees 10 crores or more and turnover of 50 crore or more shall be certified by a practicing company secretary. All these are very important points. It shall be form MGT 8. Point number 1, 2, 3, 4 are very important.
Sir, can you repeat form number MGT8 alone?
8 is for point number 4, friend.
Thank you, sir.
Every company other than OPC in each year hold a general meeting as its annual general meeting. It's very interesting, no? You see that word, every company other than OPC. OPC means one person company. One person company need not hold a annual general meeting. For a very simple reason, a man cannot meet himself. In one person company, there is only one member. In all other companies, there are 2 or 7 or more than that. So that's why one-person company is exempt from conducting the annual general meeting. Okay. Our annual general meeting shall be called during the business hours, that is between 9 a.m. and 6 p.m. on any day that is not a national holiday. Now, what is a national holiday? National holiday is, there are 3 days which is national holiday. 26th January, Republic Day. 15th August, Independence Day. 2nd October, Gandhi Jayanti. Only these 3 are called as national holiday. In any other day, conduct the annual general meeting. Okay, I have given a point over there. It will be interesting to know the annual general meeting can be held on a Sunday or a public holiday, which is not a national holiday. Public holiday and national holiday are two different things. For instance, Ramzan, Deepavali, New Year is a public holiday. It is not a national holiday. Can I hold the AGM on Deepavali day? Yes, I can hold the AGM on Diwali day. Nothing wrong in that. It is not a violation of the law. Sir, who will come for the meeting? That is a different story. Okay. But can I conduct legally? Yes, I am allowed to conduct it. A general meeting can be called by giving not less than 21 days notice, either in writing or through electronic mode. The meeting can be called by giving a shorter notice with a consent in writing or in electronic mode of not less than 95% of the members who are entitled to vote at such a meeting. In case of a public company, the quorum for general meeting shall be 5 members personally present if the number of the members as on the date is not more than 1,000. 15 members if number of members is more than 1,000 but not more than 5,000. 30 members if more than 5,000. Friends, I will tell you this. This is something very critical, you know. Sir, a company having more than 5,000 members, won't 30% will come for the meeting? No, they won't come. I will tell you. I know a company. I was assisting a company where there were 250,000 shareholders were there. Imagine how many members could have attended the meeting. 6 persons came for the meeting. Okay. So please understand that these are the numbers which has been given to in order to maintain the corporate governance aspect. So getting these numbers itself is very difficult. And if you could look at the word, they are using the word 5 members personally present, 15 members personally present, 30 members personally present. That means proxy shall not be counted for the quorum. Proxy shall not be counted for the quorum. Only the members who are personally present are counted for the quorum. Okay. Yeah, articles of a company can provide for a larger number of members as a quorum. That is allowed. Beyond this, it's allowed. But you cannot present, give you a number lesser than this, but you can present a give you a number larger than this. So all these numbers you need to remember. Up to 1,005, up to 5,015, more than 5,030. Remember these numbers. In articles of a company may provide for a quorum of a larger number of members. In case of private companies, 2 members personally present shall be the quorum. Friends, mock test question papers question, point number 11. In case of a private company, 2 members personally present shall be the quorum for a meeting. In case of the private company, 2 members personally present shall be the quorum. Please note on that. There is a meeting which has been adjourned due to the lack of quorum. In that meeting, first meeting I am conducting on 21st November. Today I am conducting. This day, the number of members present are, so let's say 30 is required, only 20 of them are personally present. I adjourn the general meeting to another day. Let's say I am going to conduct it on 5th of December. On 5th of December meeting, both members personally present and as well as proxy shall be counted for the quorum. Please note it down. In original meeting, member should be personally present. In the adjourned meeting due to lack of quorum, whether the member is present or proxy is present, both are counted for quorum. One member present personally or by proxy shall not constitute a quorum at general meeting. Adjourned due to lack of quorum. One member present personally, because one member will not constitute a quorum. Okay, one member will not constitute a quorum. Two members should be present in order to constitute a quorum. Okay, as I told you, a man cannot meet himself. In case of an adjourned meeting or change of a day or time or place of the meeting, a company shall give not less than 3 days notice to the member, either individually or by publishing an advertisement in the newspaper at the place where the registered office of the company is situated. In case of an adjourned meeting or a change of day, time, place or place of the meeting, the company shall give not less than 3 days to the member, either individually or by publishing an advertisement in the newspaper at the place where the registered office of the company is situated. Articles of the company may provide that the chairperson, if any, and the board shall preside a chairperson at every general meeting of the company. If the articles do not provide otherwise, the members personally present in the meeting shall elect one of them to be the chairperson. The proxy has no right to speak at the meeting. The proxy has no right to speak at the meeting. So then what he will do, he will come and vote. That's all, friends. He has been appointed for voting, so he will come and vote. He should not speak at the meeting. A proxy shall not act on behalf of more than 50 members and holding in aggregate not more than 10% of the total share capital carrying voting rights. A proxy shall not act on behalf of more than 50 members and holding in aggregate not more than 10% of the total share capital of the company carrying voting rights. The ordinary business can be transacted at AGM as per section 102. There are 4 ordinary business. I hope you all know what is ordinary business. Yes. Ordinary business are adoption of accounts, board's report is called as ordinary business. Second one, declaration of dividend. Number 3, appointment of auditors. Number 4, appointment of a directors other than the retiring directors. These are all called as the ordinary business at the annual general meeting of the company. If these 4 transactions are transacted in the extraordinary general meeting, if these 4 transactions are transacted in the extraordinary general meeting, then these itself will be called as a special business. Any business transacted in extraordinary general meeting is a special business. Someone has asked me a query, what about remuneration? Remuneration of a director is not an ordinary business. Remuneration of an auditor is an ordinary business. Remuneration of director is not an ordinary business. Remuneration of an auditor is an ordinary business. Subsequent first AGM should be held within 18 months of the incorporation, but within 9 months from the end of the financial year. This first part has been done away actually. In amendment, they have removed it. The first AGM should be conducted within 9 months from the end of the financial year. Financial year means 31st March is the end of the financial year. From there on, within 9 months, it should be conducted. Okay. Suppose a company is getting incorporated on that. Please note down in your notebook. I want you to note it down in notebook for understanding this concept. If a company is incorporated on 31st December 2020, financial year ends on 31st March 2021. When the AGM should be conducted, first AGM on or before 31st December 2021. On or before 31st December 2021. I will just change one day. Company is incorporated on 1st January 2021. Financial year ends on 31st March 2022. AGM should be conducted on or before 31st December 2022. For a company which has been incorporated between 1st January to 31st March, the financial year will not be this year's ending of financial year. It will be next year's ending will be taken as financial year. Are you getting it? You want me to repeat again?
Can you repeat it? Sorry, sir. Can you repeat?
If a company, you have noted down the illustration what I told?
Yes, sir. Yes, sir.
If a company is incorporated between 1st January to 31st March, the financial year will end not on the current year, it will end in the subsequent year. So from there on, 9 months will be there. Okay, I go to the next point. The AGM is to be held within 15 months of previous AGM, but within 6 months of the end of the financial year. The AGM can be called by National Company Law Tribunal also on the application of the member. AGM can be called at a shorter notice than of at least 21 clear days with the consent of the 95% of the members entitled to vote. AGM can be called at any place within city, town or village in which the register office is situated. AGM adjourned due to lack of quorum can be called at any time, any day, at any place as the board may determine. I told you 27th point already. EGM is extraordinary general meeting by the board on requisitions to be called within 45 days. Requisition means members say that please call upon the EGM. That is called as a requisition. It should be called within 45 days of the requisition. The EGM by requisition is to be called within 21 days and did not call within 45 days. From the date of the deposit of the requisition, it can be called by the requisitionists themselves. EGM may be called by the NCLT, EGM may be called at any time, any day, any place, since the act is silent on this point. For requesting 10% paid up share capital holding voting power should call for the request. A person who holds majority in value of the paid up share capital held by all of them can call the meeting as per 100. That means together, if they hold 10%, then also they can call. Single shareholder holding 1%, other shareholder holding 9%. They both together can call for the requisitioners meeting. That is entitled to be under the law. The class meeting of members may be convened by the company. The shareholders' right may be varied with the consent of the writing of the holders of at least 75% of the issued shares of that class. Special notice is required to be remove the directors before the expiry of the term. Ordinary resolution not passed by all the members are not required to be filed with the registrars. Then special resolution, if it is passed by the members, then it need to be filed with the registrar mandatorily, irrespective of the kind of company. It should be filed in the form MGT 14.
So can you repeat the form MGT 14?
I have given it in the chat, friend. Form MGT 14 need to be filed with the ROC whenever a special resolution is passed by the shareholders at the general meeting. That should be filed with the ROC within 30 days of passing of the resolution. Am I clear to you, Janani?
Yes, sir.
Ordinary resolutions, 39th point, minutes of the board meeting cannot be inspected by the member of the company. It can be inspected only by the directors. Friends, there are two ways of voting at the meeting. One, by show of hands. Show of hands means raising the hand. One shareholder will get only one vote. There is another way of voting is poll. The poll can be voted by one shareholder will have vote in proportion to the share capital held by them. If they have 5,000 shares, they will have 5,000 votes. If they have 10,000 shares, they will have 10,000 votes. In show of hand, one share, one vote. In poll, in show of hands, one shareholder, one vote. In poll, one share, one vote. In show of hands, one shareholder, one vote. In poll, one share, one vote. The poll can be demanded by the members holding 1/10 of the total voting power. Whenever a poll is demanded by the shareholder, it should be taken immediately. If the member has not paid the call in arrears, the call money has not been paid. If there is a call in arrears, then the member shall not be entitled to vote. A AGM may be held on a national holiday in case of a private company. An adjourned AGM of a public company can also be held on a national. Please note down that it's an exemptional provision which has been given. Proxy cannot cast vote against the wishes of a person who has appointed him. Hence, proxy has a relationship of a principal and agent. Proxy has a relationship of a principal and agent. Member is the principal, proxy is the agent. If principal says vote yes, proxy cannot vote no. So proxy should vote as per the wishes of the principal. Proxy appointed by a body corporate is considered as a member personally present for the quorum. Proxy bearing the latest date will supersede the earlier one. That means two proxies are appointed. Whichever is the proxy is the latest proxy that will prevail. When in case of the ordinary resolution, 51 is required. Suppose 100 members are there, 51 should say yes. If it has come 50-50, in that case alone, there is a concept called casting vote. Chairman of the meeting can vote upon. That is called as casting vote. A proxy can be counted as a quorum in three cases. AGM by NCLT under section 97, EGM by NCLT under section 98, meeting adjourned due to lack of quorum. In these three cases, proxy will be counted for the quorum. One member can constitute a quorum in AGM by NCLT and 97, EGM by NCLT and 97. In these two cases, one person will constitute a quorum. This is an exception to the normal rule that two persons are required for the quorum always. Whereby provision contained in the Act or in the articles of the association of the company, the special notice is required. The notice of the intention to move such a resolution shall be given to the company by the members holding not less than 1% of the total voting power or holding shares on which an aggregate sum of not less than 5 lakh rupees has been held by them. So they should hold 5 lakh rupees in order to give the special notice. They should have 1% of total voting power, or they should have 5 lakh rupees in order to give the special notice. There is a standards which has been issued called secretarial standards for conducting the general meeting and board meeting that should be followed by all the company. Listed public company shall prepare and file with the ROC a report on EGM confirming that the meeting was convened, held and conducted as per the provisions of this act and rules they were under. So these are all the matters which are relating to the meetings, friends. I will give you 2 to 3 minutes break right now. What you do is, if you are not sitting with your notebook and pen, please bring your notebook and pen. I am going to tell you the important concepts which you need to concentrate from the mercantile law, labor law, and company law. In all the concepts whichever is important, I am going to tell you the important concepts. Please go and arrange your pen and notebook. I am going to tell in the next 15-20 minutes what are all the important topics which you need to know for the examination. So please arrange and come assemble in another next 2 minutes. Friends, are you ready? May I tell the important topics? Yes, okay, good enough. I'm starting from the contract. I'm starting from the contract law. I got it. I got it. I got a S from all. I'm starting from contract law. In the contract law, note down the important topics. Contingent contract, quasi contract, wager, wager, bailment, bailment, doctrine of supervening impossibility, doctrine of supervening impossibility, agency, agency, okay. These are all the some of the important topics, along with capacity of parties, that is unsound mind, unsound mind, coercion, coercion, okay. Friends, what I told some of my friends already which texted me, I am going to send a simple 9-page or 8-page notes for the contract law, a sneak peek, which you can refer for the examination. Okay, that I will send it to you. Give me time. I will send you numerical limits on company law, special resolution, ordinary resolution, and then this which I told you right now, new sneak peek on contract law. These four I will send it to you tomorrow. Wait for me patiently. Okay. Don't send me the text until I send to you. Wait for me. Tomorrow I will send it to you, and then I will put it in the group that I have sent to you. Okay. Until that time, please wait for me. Okay. Then, in Sale of Goods Act, in Sale of Goods Act, agreement to sell, agreement to sell, implied conditions, implied warranties, implied conditions, implied warranty. Nemo dat quod non abet. In some other language for you. Nemo dat quod non abet. Caveat emptor. Caveat emptor. Unpaid vendor. Unpaid vendor. Right of lien. Right of lien. Auction sale. Auction sale. I'm going to the partnership law. In the partnership law, minor as partner. Minor as partner. Partnership is at will. Partnership at will. Rights of the partner. Rights of the partners. Retirement of a partner. Retirement of a partner. Implied authority of partners. Implied authority of partners. In Negotiable Instruments Act, endorsement, older in due course, basics of NI, that is check, promissory note, bills of exchange meaning. Check, promissory note, bills of exchange meaning. Material alteration. Material alteration. Dishonor of check. Section 138 to 142. Dishonor of check. Section 138 to 142. Concept of undi. Concept of undi. In limited liability partnership, designated partner. Designated partner. In investigation of LLP. Investigation of LLP. Change of name of LLP. Shifting of registered office of LLP. Shifting of registered office of LLP from a state to another state. In labor law, I'm starting with Factories Act. I have told you in detail that I'm teaching it. Pardon me? In labor law, in Factories Act, we have discussed already, but I'm still telling you. Working hours, manufacturing process.
Sir, can you repeat the first point?
Working hours, manufacturing process. Number 3, welfare measures. That is, you need to remember the table which I have given in your labor law revision material. I have given you table. No, that table you need to remember. For 30 women's employed, creek should be there. 150 lunchroom should be there. Or 250 canteen should be there. That numbers, that table you should remember. Whitewash provision. What is the interval for whitewash? 14 months. That should be remembered. Gratuity Act. They might ask you numerical problem. for the computation of the gratuity. That's very simple formula which I have told you. 15 by 26 into last done wages into number of complete year of service, that one. Bonus Act. Disqualification of bonus. Deduction from bonus. Accounting year. ESI contribution percentage, EPF contribution percentage. Contribution percentage, EPF contribution percentage. In company law, lifting of corporate wheel, prospectus misstatement liability, alteration of MOA, alteration of MOA, entrenchment, sweat equity shares, securities premium, buyback ceiling limits, preference shares time period of redemptions, DRR limits, debenture redemption reserve limits, entire concept of meetings need to be learnt properly, specifically proxy, quorum, kinds of directors, limits of women director, limits of independent director, ceiling limit, when it should be appointed, when they should be appointed, independent director, women director limits. Additional director, alternate director. Additional director, alternate director. Rotation number, rotational director, non-rotational director, how much number? 2/3 should retire in a year. 2/3 should retire in a year. Powers of the board of directors. Powers of the board of directors.
Sir, sorry for the interruption. Can you repeat it, sir? Due to network connection, I left out. Sorry. After types of directors.
The recorded video will be sent to you. You can listen to that.
Okay, sir. I wrote till types of directors. From then it got structures.
Managerial remuneration limits, you remember, no, for that in whatever we learn in the corporate accounts, the same limits. 11% maximum ceiling, 10%, all those things. Someone has given for their chat purpose, they have given it. You can note on from there, friends. Thanks for the help, friend. Aravind. Managerial remuneration percentage. Ethics is a very small chapter. Study your ethics well. Ethics may not be useful for life, but useful for the CMA examination. So study that properly. So that comes 15 marks deal, no, in the examination, 10 to 15 marks deal. So use it worthy. That's very, very critical. Your 10 marks, easy 10 marks it will be. Okay. So thanks a lot, friends. With this, I'm closing off the session on the revision of law. Do well. God bless you all. Take care of your health. Write well. Be brave. As much as possible, adopt to the home-based online examination. Take care. God bless you all. Keep in touch. I will send you the notes tomorrow, friends. Thank you very much.